Hello, hello. Here we are again. My name is Jax West. I run Stephen Avery Project, MAM Gossip, and Justice with Jax. I am also part of the WMP Justice Review team. And hello, Elizabeth and Rebecca. I am no relation to the Avery family. I am just an advocate for the wrongfully accused. And what else? Looking very smart. Oh, why, thank you. I just threw some lipstick on. No other makeup. All sweaty. Hair still wet from my shower. um, there are 4 parts that are on video from yesterday when we started going over Kathleen's filing that she filed October 14th of 2019. And here is the link to that if you want to read that. I thought I was being smart by, hey, on Wednesday, we'll go over Kathleen's filing as just a refresher since the state is due to respond on Friday. And then the state responded. So then I started going over the state's response last night, but so I was online reading from roughly 2 p.m. to 11:30 p.m. and it was like, okay, I got to stop and we'll continue today. So this is the state's response to Kathleen's filing. This is not the court. The court typically has 30 to 60 days to respond. So we should hear something in 30 to 60 days. So, Keith, so I take it he isn't getting out. Well, not at this point. He's not. Our system is horrible, and it is set up in such a way that it is really easy to put people in prison and really hard to get them back out when they are innocent. Kathleen Zellner has stated that it typically takes her 15 years to get out somebody who is innocent. And I was talking with Tammy. Tammy is the founder of the WMP Justice Review group that I am part of. And I don't pretend to be a lawyer, and I am not here to try and explain to you the laws and all that, because I don't know it. I don't know. Tammy is the person who I know knows it all, and I was talking to her just before going live here, and I was asking her questions about all of this. Now, mind you, Tammy isn't involved in Stephen's case, and she doesn't really follow it. She just knows the basics, and she knows our laws here in Illinois, so she doesn't know Wisconsin laws. But she was explaining to me things like, I tell her how confused I am on things that are in here, that, you know, they're arguing this, that, or the other, but it's just basically, now Tammy didn't put it this way. This is me putting it this way. Our system is just basically set up in such a way that it makes it almost impossible to get back out. That you have to do this by such and such a time, and if you didn't, it's lost, and now you lose that opportunity to bring that up and all this. It really sucks. Sonia is saying June 11th in 2 weeks. How are you? Where does the June 11th day? Oh, Ian saying, I thought Zellner replies first before state in 30 to 60 days. See, I get all lost in all of that. I would love to see Kathleen's response to all this nonsense. All right, so while I am over on this screen reading this, I will not be seeing your questions and comments. I occasionally glance over here because I'm trying to make sure people are behaving. But so I may not see your questions or comments. So don't be offended if I don't answer you. I am reading this. And we are on page 83 out of 130. And Keith saying, was it a negative response? Well, it's always going to be a negative response, Keith, because this is the state trying to keep Stephen in prison any way they can. Oh, Sonia says that June 11th is Kathleen's due date to respond. Well, thank you so much for that, Sonia. And I see Christina just posted in Justice with Jack's discussion. So hopefully that means Christina is one of our moderators here. So hoping that the moderators that come on, they will be able to answer your questions while I'm doing this. And they will try and get people to behave. I know, like last night, we had several different trolls, and I will never get that. If you believe Stephen or Brendan are guilty, there's no reason for you to be on Stephen Avery Project or an MAM Gossip. We are a supporter page, and we're just we know their innocence. So there's plenty of guilter pages that Stephen's family runs. So you can hop on over there and go talk all you would like about how you think he's guilty. We don't entertain that talk here. So, okay. Where we're at, like I said, we are on page 83 out of 130. If you missed yesterday's, you can find them in the videos here on Stephen Avery Project. So there are 4 parts to where I was reading Kathleen's brief, which we left off. We left off on page 126 out of 150. So I don't know if I will even at this point go back and follow up on that. Oh, Christina, are you saying I put you to sleep last night? How rude. So there's 4 parts of that because Facebook was being stupid, and I had to keep restarting the video. And then the one of us reading the beginning of this filing is almost 3.5 hours long. So you can find all those in the videos here. All right. So we are on page 83. And we're starting where it is Roman numeral 2. Nothing required the circuit court to allow Avery to pursue his claims piecemeal, so it appropriately denied his October 6, 2017 motion for relief from judgment. On October 6, 2017, Avery filed a, quote, motion for relief from judgment, unquote. There, he stated that on September 18, 2017, he met with the state and reached an agreement to schedule additional tests on the victim's RAV4. Avery said that, quote, the parties also had an agreement that the previously filed motion for relief would be amended, unquote. He claimed that after this meeting, he, quote, intended to inform the court that an amended motion would be filed, unquote, but that he, quote, did not anticipate, unquote, the court denying his motion while he pursued further testing. He asked the court to vacate its October 3 order denying his motion. The circuit court denied this motion in its November 28, 2017 order. A. The circuit court reasonably explained its decision denying Avery's motion to vacate judgment. Quote, the decision to grant relief from a judgment is discretionary, unquote. Quote, it is also within the discretion of the trial court whether to allow an amendment to a motion for post-conviction relief pursuant to section blah statutes, unquote. Oh, Kristen. The circuit court properly exercised its discretion when it denied Avery's motion to vacate its judgment, denying his June 2017 motion. The court explained that it was denying Avery's request because Avery chose to file an incomplete motion and never asked the court not to rule on it, nor alerted the court to any negotiations about, quote, the scheduling of a hearing that the court had yet to grant, unquote. it was, quote, only after the court fully considered the evidence submitted and issued its final ruling, unquote, that Avery, quote, finally alerted the court, unquote, that he was working on further evidence to support his arguments, and no agreements on scheduling, quote, were submitted to the court for its approval until after the final decision was made to deny the defendant's original motion, unquote. The court determined that Avery, quote, cannot try to amend a motion that was filed without reservation only after he receives an adverse ruling, unquote, and denied the motion for relief from judgment. That is a reasonable decision that is based on the facts of record, and accordingly, the court did not erroneously exercise its discretion. Avery provided nothing in his October 6, 2017 motion showing the circuit court should have withheld ruling on his June 2017 motion. He essentially just told the circuit court that he didn't realize the court might rule on it and that he'd intended to tell the court he planned to supplement his arguments later. The circuit court was not required to let Avery supplement his motion, even if he'd timely requested to do so, let alone allow him to supplement an already denied motion that he filed without reservation. It adequately explained its reasons for refusing to do so. The court properly exercised its discretion when it denied Avery's motion for relief from judgment. B. Avery improperly argues for the first time on appeal that the court's refusal to vacate its judgment violated the 2007 preservation and testing order. Nevertheless, the claim is meritless. 1. Avery forfeited his argument that the 2007 preservation order allowed him to pursue his claims piecemeal. And so that's something that they keep arguing in here, which may all be part of our legal system that I just will never understand. But it's trying to say that you have to submit everything at one time. That's why they keep using the word piecemeal. That they submitted this at this time and then submitted this at that time. And it's just ridiculous to me. Anytime you come across evidence that could prove that somebody is in prison for something they didn't do, you should be able to go to the court for that. It shouldn't be you have to wait until you have all this at once and give it to us at one time, and if you don't, it's off the table. You can't do it. So I don't care if that's what our laws say. It's wrong. So when you have somebody come forward at such and such a date that saw something but didn't say something or didn't know to say something, and now they come forward, you should be able to go to the court and go, hey, this just happened. We shouldn't just be dependent on DNA and DNA alone to get out the wrongful convicted. Avery has not attempted to show that the circuit court erroneously exercised its discretion in denying his motion to vacate judgment based on the reasons Avery actually offered to it, and instead makes a new argument on appeal. Now, Avery claims that the circuit court's refusal to reopen his June 2017 motion violated the 2007 court order for preservation and scientific testing of certain evidence. This argument appeared in none of Avery's motions to the circuit court. Again, this court, quote, will not ... When I say ... when there's ... in these things, it means they're taking out some of the context and only keeping what they want us to see from a statement or whatever. So that's why I include the ... when I read this. So you know this isn't the whole thing that was said. This is just what they want us to know. So, quote, will not ... blindside trial courts with reversals based on theories which did not originate in their forum, unquote. Avery cannot show that the circuit court erroneously exercised its discretion by relying on the argument on appeal that the circuit court never heard. The argument is forfeited. Avery has also attempted to unfairly detect blame onto the state for the result of Avery's own decision to prematurely file an incomplete Section blah blah motion. And when I say blah blah, it's because it's a whole lot of numbers for whatever this statute is, and we're not going to read those. You want to know what all the numbers are from the statutes, you can read this yourself. I posted the link for you. And then failed to alert the court to that fact. No matter what was agreed to by the parties about scheduling forensic testing, particularly at the September, they have September emphasized, September 2017 meeting, it doesn't explain why Avery filed an incomplete motion in June, they have June emphasized 2017, and never alerted the court that he planned to supplement it. Wisconsin statute blah blah states that there is no statute of limitations for bringing a section blah blah motion. As the circuit court aptly observed, Avery has never offered any reason why he filed his June 2017 motion at all, if he had further investigation he wanted to complete, or why he waited months to even think about alerting the court that he planned to supplement it, and then still didn't notify the court until after he received an adverse ruling. Indeed, Avery still has offered nothing in this regard. All right, I have to pause here for a second. Again, this legal bullshit of running around here, where the bottom line is it was agreed to that stuff was supposed to be kept, and Stephen was able to test it whenever he wanted, whenever new testing became available, and that the RAV4 was to be given to them for their own testing. And so all this, don't look over here. Don't look at that. We're going to keep you from looking at the RAV4. Look here. That you should have done this on such and such a date. And since you didn't say it on such and such date, it's off the table. The state is not responsible for Avery's unilateral decision to file an incomplete motion and presume the court would not decide it while he conducted further investigation. That choice and its consequences rest solely with him. The circuit court properly exercised its discretion in denying Avery's motion to vacate the October 3 order. 2. The 2007 preservation order does not give Avery a license to pursue available claims piecemeal. Give him the stuff, and he won't have to keep filing for it. Regardless, Avery's argument that the circuit court's refusal to vacate its judgment violated the 2007 order is meritless. The 2007 preservation order requires the state to preserve indefinitely, quote, all, and now they have the word bloodstains emphasized. So, quote, all bloodstains, unquote, and, quote, all swabs or other collected swabs of bloodstains, emphasized, that the state believes contain Stephen Avery's DNA and that were found in or on Teresa Halbach's vehicle, unquote, and, quote, portions of all items submitted by the state to the FBI laboratory, unquote, for EDTA testing. Paragraph 4 of the order further states that Avery, quote, may at any time submit the bloodstains, swabs, and items described in paragraphs 1 through 3 for independent scientific testing without further order of this court, unquote, quote. The 2007 order says nothing about collection or, quote, further forensic testing, unquote, of other evidence, or about relieving Avery of the rules of post-conviction procedure when raising claims related to forensic testing. And the circuit court's October 3 order did not prevent Avery from seeking any further testing. Well, how can he test a RAV4 if he doesn't have it? To overcome the procedural bar and raise claims related to that testing, though, Avery would still have to meet the post-conviction pleading requirements. That includes showing a sufficient reason why he could not have sought this testing and brought any claims related to it at the time he filed his earlier motions, if he wants to raise claims related to subsequent testing. And the footnote says, Avery attempts to bootstrap into his appellate brief an argument that he was due additional testing pursuant to Wisconsin statute blah blah. This court explicitly refused to allow Avery to litigate a Wisconsin statute blah motion as part of this appeal, stating that, quote, the scope of this appeal is limited to a review of the circuit court's orders denying Avery's Wisconsin statute blah blah motions, unquote. Whether Avery could meet the requirements for testing and post-conviction relief under Wisconsin statute blah blah is not at issue here. The state will not discuss it further. Okay, state. They will not. In any event, none of the additional items on which Avery relied in his motion to vacate fall within the 2007 order. Avery claimed he planned to test for DNA swabs from the RAV4's battery cables, to collect and test new swabs from the bar under the driver's seat, hood crutch, interior hood release, license plates, a lug wrench, and to conduct, quote, a complete examination of the interior and exterior of the RAV4 for additional forensic evidence, unquote. None of that is bloodstain evidence collected from the RAV4 or items submitted to the FBI for EDTA testing. An examination of the RAV4, quote, for additional forensic evidence, unquote, is not even a request for scientific testing of anything. Even if Avery were correct that the 2007 order relieved him of showing a sufficient reason why claims related to scientific testing of the evidence listed within it could not all be raised in a single motion, which he is not, nothing Avery submitted to the circuit court would have triggered the 2007 order. The 2007 preservation order does not give Avery a license to pursue his claims piecemeal, nor did it require the circuit court to allow him to amend his motion after he received an adverse ruling. The court appropriately denied Avery's motion to vacate its October 3, 2017 order. 3. The circuit court properly exercised its discretion when it denied the claims raised in Avery's motion for reconsideration as procedurally barred. On October 23, 2017, Avery filed the motion for reconsideration of the circuit court's order denying his June 2017 motion. There, he alleged, 1. The circuit court, quote, failed to properly accept the factual allegations in Mr. Avery's motion as true, unquote. 2. The circuit court misconstrued his expert opinions. 3. The circuit court erred when it concluded that ineffective assistance of post-conviction counsel must be pursued via a Knight petition. 4. The circuit court erred in finding that he did not show a sufficient reason why his claims could not have been raised earlier. 5. He had, quote, new evidence, unquote, of a Brady violation consisting of a, quote, new witness, unquote, Kevin Romlow, who allegedly told Sergeant Colborn that he saw a car similar to the victim's RAV4 outside the Avery property on November 3 and 4, but no police report existed about the conversation. So, yeah. Again, with the, oh, we can't believe private citizen by their word, but we're supposed to just believe Colborn, who didn't put it in a report. Oh, if it had happened, he would put it in a report like he did when he was called at the jail and told that they had the wrong person for Penny Bernstein's attempted rape. Okay. 6. That he had, quote, new evidence, unquote, that trial counsel were ineffective by failing, quote, to investigate and present to the jury, unquote, quote, impeachment evidence related to Bobby Dassey, the killer, consisting of Brian Dassey's 2005 statement to police that Bobby, the killer, said he saw the victim leave the property. 7. Avery had, quote, new evidence, unquote, purportedly providing a motive for Bobby Dassey, the killer, to murder Ms. Hallback, consisting of forensic computer examiner Gary Huntz examining the forensic image of the Dassey computer, well, again, it's the Bobby computer, provided to the defense before trial, and finding violent pornography and images of dead bodies. Because let's not worry about those on a computer, but we're going to worry about pink fuzzy handcuffs. 8. Avery had, quote, new evidence of a Brady violation, unquote, consisting of Denise Heidel stating that she had a phone conversation with the victim at 11:35 on October 31 about an appointment, which Heidel told the authorities. Avery filed 2 supplements to this motion, adding arguments and claims. Avery alleged in his first supplement that, quote, as undersigned counsel's investigation remains ongoing, additional new evidence continues to develop, unquote, to support his claims. He then raised 5 new ineffective assistance and newly discovered evidence claims related to the contents of the Bobby computer and provided an affidavit from Brian Dassey as further impeachment evidence related to Bobby's testimony about Halbach leaving the property. In his second supplement, Avery alleged that the state committed a Brady violation by failing to disclose to the defense a CD containing Detective Mike Velli's investigative report of his forensic investigation performed on the Dassey computer, which he alleged, quote, must contain evidence favorable to Mr. Avery, unquote. Avery also added additional argument from his police procedure expert that Scott Tadek, the other killer, was not sufficiently investigated and provided an affidavit from Attorney Strang concurring that he was ineffective for failing to hire a blood spatter or ballistics expert. A. Legal standards and standard of review for motions for reconsideration. Quote, to prevail on a motion for reconsideration, the movant must present either newly discovered evidence or establish a manifest error of law or fact, unquote. Again, to qualify as newly discovered, the evidence must meet the 5-prong test stated in Avery, which is a different case with somebody's has the same last name of Avery. It is no relation to Stephen. It, quote, does not include the new appreciation of the importance of evidence previously known but not used, unquote. Evidence previously known includes evidence that was knowable by counsel. This court, quote, reviews a circuit court's denial of a motion for reconsideration to determine if the court properly exercised its discretion, unquote. B. The circuit court appropriately exercised its discretion to deny Avery's motion for reconsideration. 1. The circuit court properly found that the claims raised in Avery's motion for reconsideration were procedurally barred. Okay. The circuit court applied the correct law to the facts and gave a rational explanation for denying Avery's motion for reconsideration. Now that I'm seeing that again, I want to write this down. Okay, so I remember it because I forget. So June 11th is when saying KZ's response is, right? That should make things interesting because June 9th is Marnie Yang. And June 28th is Melissa Kalyazinski. All right. I need to remember those dates. Let me put it on my little post-it note. All right. So there we go. There's our order of, so June 9, Marnie Yang, June 11, KZ's response, June 28, Melissa Kalyazinski. Melissa Kalyazinski is another case of Kathleen Zellner's. All right, back to this. The circuit court applied the correct law to the facts and gave a rational explanation for denying Avery's motion for reconsideration. Accordingly, it properly exercised its direction in doing so. The circuit court observed that in Avery's, quote, numerous filings after October 6th, he submitted a substantial amount of what he calls newly discovered evidence. That characterization is incorrect, unquote. Instead, Avery's motion for reconsideration and subsequent supplements, quote, outline new arguments and new theories of the case for the court to consider, unquote. But, quote, what was missing in the wealth of arguments and documentation is any explanation as to why the defendant filed his motion on June 7, 2017, knowing that further scientific testing was required to complete his motion and that considerable investigation was still being conducted by the defense, unquote. Whatever case expressly bars such claims, quote, unless good cause is shown as to why the issue was not included in the original filing, unquote. The court explained that, quote, there is no reason asserted or good cause shown as to why the motion was submitted, ... unquote, before all of Avery's investigation was finished. In Avery's post-October 3 filings, he, quote, made it abundantly clear that he knew he had substantial investigation to complete, unquote, but provided, quote, no explanation as to why, without an impending deadline to meet, the defense rushed ahead and filed the motion prior to his investigation being completed, unquote. The court stated that it finds no, quote, finds no basis to reverse its previous decision, unquote, and Avery's new arguments and alleged, quote, new evidence, unquote, to back up his old arguments, quote, should have been asserted in the defendant's first motion pursuant to the holding in the case Escalona Naranjo, unquote. That was a legally and factually sound evaluation of Avery's post-October 3 motions. Quote, the purpose behind Wisconsin statute blah blah is to avoid successive, it has successive emphasized, motions for relief by requiring a defendant to raise all grounds for relief in one motion, unquote. Avery repeatedly claimed that everything he alleged was, quote, new evidence, unquote, but it was new only in the sense that Avery did not investigate and develop an argument about it before filing his June 2017 motion. Indeed, Avery admitted that the only reason, quote, additional new evidence continued to develop, unquote, was because, quote, undersigned counsel's investigation remained ongoing, unquote. As the circuit court correctly observed, that is exactly what Escalona Naranjo and Wisconsin statute blah blah prohibit. Successive motions based on new arguments that are only new because the defendant filed a motion without investigating and presenting them. The mere fact that an argument was not raised in a prior motion is not a sufficient reason for raising it in a subsequent one. And what was uniformly absent from Avery's post-October 3 motions was, quote, any explanation as to why the defendant filed his motion on June 7, 2017, knowing that further scientific testing was required to complete his motion and that considerable investigation was still being conducted by the defense, unquote. But again, how can he do all the testing when you're not giving him the stuff to do the testing? So he has to file and point out that he doesn't have the stuff. I said, bad check for me. Avery still does not attempt to direct this court to any point in the record where he provided any sufficient reason why these claims could not all have been raised in a single motion or why he filed his June 2017 motion prematurely. Claims that his motion for reconsideration was, quote, properly filed, unquote, under Wisconsin statute blah blah, but that statute only applies to bench trials. Regardless, the circuit court did not deny his motion as improperly filed. It denied it because it found all of the arguments within it procedurally barred. Avery has provided no real argument that the circuit court's ruling on the procedural bar was legally or factually unsound. Instead, Avery has simply pretended that he submitted these arguments and evidence in his first motion by conglomerating his ineffective assistance of counsel and Brady claims into topical issue sections in his appellate brief, arguing their merits and using these belatedly raised arguments and exhibits to support them. There goes my post-it note reminding me that it's called a footnote. Apart from being a disingenuous presentation of his claims on appeal, by arguing the merits of these claims in his appellate brief, Avery failed to address the issue on appeal, which is whether the circuit court properly exercised its discretion in finding these claims procedurally barred and denying his post-October 3 motions without a hearing. What little argument Avery has provided on this point again reflects a misunderstanding of the procedural bar. The question is not whether Avery had all the evidence in hand in June 2017. That would amount to allowing defendants to escape the procedural bar by simply failing to investigate their available claims, which is what Wisconsin statute blah blah was designed to prevent. The question is whether all of Avery's claims, quote, could have been brought at the same time, unquote, if he had completed his investigation before filing his section blah blah motion. That means any claim that was available to be raised, if Avery could have discovered it by investigating it in June 2017, is procedurally barred. Since the answer to that question is yes, nearly all of Avery's later claims could have been raised in June 2017 if he had investigated them, and particularly the multitude of new ineffective assistance claims, considering that an attorney can only be ineffective for failing to take actions available at the time of trial. Avery had to show a sufficient reason why these claims could not have been developed in June 2017 to overcome the procedural bar. He also had to sufficiently plead the claims. Avery failed to do either in his motions or his appellate brief. Moreover, Avery failed to recognize that his June 2017 motion was not his first attempt at post-conviction relief. So, Avery also had to provide sufficient material facts to show a sufficient reason why the claims raised in his motion for reconsideration could not have been raised on direct appeal or in his pro se motion. Avery made no real attempt to do that either, and to the extent he addressed it at all, he just made conclusory allegations of ineffective assistance of post-conviction counsel. In particular, Avery's unmade argument that he could not have raised in his June 2017 motion his claim that Strang and Buting were ineffective for failing to, quote, investigate and impeach, unquote, Bobby Dassey, the killer, based on Brian Dassey's discussion with police would fall flat, given that it is based on a police report made before trial. But so does the underlying claim. The record shows that trial counsel thoroughly cross-examined the killer, Bobby, including establishing that all he could say was he saw Halbach taking a picture and then saw her RAV4 when he was leaving to go deer hunting. Avery's attorneys further discredited Bobby's testimony about Halbach being at the Avery property at 2:30 p.m. through Joellen Zipper's testimony that Halbach could have been at the Zipper's household as late as 3:30 p.m., and through bus driver Lisa Buckner's testimony that she saw Halbach there while dropping off the Dassey boys from school. Buckner testified that her regular route put her at the Avery property at the same time every day, which was between 3:30 and 3:40 p.m. Lisa Buckner, if you happen to watch this, or anybody out there knows Lisa Buckner, I really, really, really want to talk to her. She can come on here. We can do a Facebook Live together. We can do it completely off the record. We can do it over the phone. I can drive to her. Whatever. But I have a video that I did where I wore a bright orange shirt. I was holding a camera. I stood down in front of Barb's trailer where her van had been parked. And then my partner stood down at the bus stop. And first he was zoomed in. So you saw me there and saw my orange shirt and saw me holding the camera. Then he zoomed out so you can see what the eye would see from that distance. You could not even tell what color my shirt was. It is that far away. There is no possible way that the bus driver saw Teresa Halbach on October 31 taking pictures of that van. Now, usually when Stephen would have Teresa Halbach come there to take pictures of cars they were selling, the cars were parked down at the office. The office is by the bus stop. So the bus driver could clearly see Teresa Halbach taking pictures then. So either, and she testified that she could be confused on the day, but I need her to say where she saw Teresa Halbach standing. I don't know why nobody's asked her that, why that doesn't come out, but there's no possible way she could have seen at that red Plymouth Voyager van or whatever that was. I have completely debunked that. You can find that video. It's posted in our videos that I did a couple years ago, 3-4 years ago now. No way. No, and I am not saying anything negative about the bus driver. The bus driver said the entire time that she could be mistaken, but nobody questioned her where the vehicle was and where Teresa Halbach was. I just know there's no possible way that you can see who anybody is or what they're doing down by the trailers from the bus stop. It's not possible. Which is also where I got this. Used to be posted by the bus stop. All right. Let me return. Avery fails to explain why a single statement that Brian Dassey told police that Bobby said he saw Halbach leave the property would have tipped the scales when the wealth of other evidence pointed at Avery. And when the jury also heard multiple other accounts that conflicted with Bobby Dassey's testimony. See, and I again never understand this. So you're trying to dismiss what Brian Dassey said just because he said it, but we're supposed to believe Bobby Dassey just because he said it. Avery's complaints about trial counsel not using Brian Dassey's statement to impeach Bobby simply amount to another claim that defense counsel was ineffective for failing to conduct the defense the way post-conviction counsel would have. Sorry if you hear all the noise. Obviously, everybody in my neighborhood is weed whacking and cutting their grass. For failing to conduct the defense the way post-conviction counsel would have, which is insufficient to state a claim for ineffective assistance. But again, the merits of this claim are not before this court. The circuit court properly found that this claim was procedurally barred, because there is no reason Avery could not have raised it in his June 2017 motion. That was a legally and factually sound decision. Denying this claim without a hearing was an appropriate exercise of discretion, and Avery has failed to show otherwise. Avery further asserts that the Dassey computer, Bobby computer, would have provided a possible third-party suspect defense that Bobby Dassey killed Ms. Halbach, and that his forensic computer expert, Gary Hunt, found, quote, new evidence, unquote, on the computer to support that. But Avery again lacks a sufficient reason why he didn't raise this claim in his June 2017 motion or any of his previous post-conviction litigation. This evidence isn't new. Avery simply relied on the fact that Hunt used a 2017 forensic computer program to allege that his examination could not have been performed earlier. But when Hunt's program was available is not the question. When the information on the hard drive was capable of being found is the question. And Hunt's own affidavit states that was in 2006. But see, that again would go to ineffective assistance of counsel. If you're saying this could have been found in 2006 and Strang and Beauty did nothing to try and find this, it's ineffective assistance of counsel. Hunt's affidavit acknowledges that the EnCase forensic examination software technology was available and used in 2006, and that, quote, the corpus of data contained within the forensic image of the hard drive has not changed, unquote, since then. But it's already been said too, they didn't have that EnCase program to open that. He further acknowledges that his investigation was guided by Fassbender's report that the state's pretrial examination of the hard drive finding this same material. If it could be found in 2006, it could be found, and a claim could have been raised about it at any time after that. At any rate, the fact that Hunt used a 2017 program would fail to show why this claim could not have been raised in Avery's June 2017 motion. Apart from the claims raised in Avery's post-October 3 motions that he has obscured by amalgamating elsewhere in his brief, Avery just lists some of the things he investigated after filing his June 2017 motion and again calls it, quote, new evidence, unquote. He claims that all of these belatedly raised issues, quote, were based on the discovery of new evidence that was either withheld from Mr. Avery or, through no fault of his own, was not in Mr. Avery's possession at the time he filed his prior post-conviction motions, unquote. And the footnote says, Avery raised different claims about the Bobby computer in different motions, but has combined them into a single section in his brief. Because there were different claims raised at different times and denied on different grounds, the state has addressed Avery's claims about the Veli CD raised in Avery's May 2018 motion in issue 4. Oh, but they didn't say, and we will not talk about it anymore. Avery's claim is false. The only reason this purported evidence was, quote, not in his possession at the time he filed his prior post-conviction motions, unquote, was because he failed to investigate these claims before filing. Newly discovered evidence, quote, does not include the new but not used, and evidence previously known includes evidence that was, quote, knowable, unquote, by counsel. None of this newly discovered evidence, it was all knowable by counsel, inadmissible, or explained in section 2, below, immaterial. Avery easily could have procured these affidavits from String, Bates, Brad Dassey, and Blaine Dassey, and affidavits from Scott and Barb Toddock. Sorry. About whether Halbach left the Avery property, had post-conviction counsel investigated all of Avery's claims before filing Avery's June 2017 motion. And Scott and Barb Toddock's phone conversations with Avery, along with Barb Toddock's Facebook statement, are inadmissible hearsay, and therefore they are not newly discovered evidence as a matter of law, no matter when they took place. So when is it hearsay and when is it fact? So Bobby telling his mom that he saw Teresa Halbach leave that's hearsay. But when he says he didn't see her leave, that's fact. We can lock Stephen up for that. Hold on. Okay. Finally, Avery's claim that he found deletions on the Dassey computer was not raised in his 2017 motion for reconsideration. Indeed, Avery never raised any constitutional claim or developed any argument about this at all in any motion. This was a bare allegation in a letter Avery wrote to a civil court in August 2018, indicating that he would not be supplementing his July 6, 2018 motion. Again, Avery cannot show that the circuit court erroneously exercised its discretion in denying a motion by all right, I'm just going to start with this paragraph. I was getting a message in Squirrel. The circuit court denied Avery's motion for reconsideration as procedurally barred for raising only claims that could have been brought in a single motion if Avery would have completed his investigation before filing his motion and failing to provide any reason, let alone a sufficient one, why he filed his Wisconsin statute blah blah motion prematurely while knowing that he, quote, had substantial investigation to complete before having a full picture of all the evidence, unquote. He wanted the court to consider. That was a reasonable assessment by the circuit court, and denying these claims as procedurally barred was an appropriate exercise of discretion. Avery is due no relief. 2. Avery insufficiently pled his Brady claims about Heidel and Romlo, which are nevertheless meritless. Avery claims that he could not have included his Brady claims based on Romlo's or Heidel's information in his June 2017 motion because they did not provide their information until after he filed it. Even assuming that could be a sufficient reason for failing to raise these claims then, and assuming these events actually happened, Avery did not establish that either of these affidavits provided material evidence, and therefore they cannot support a Brady claim. The defense does not show a Brady violation by showing that the prosecutor failed, quote, to disclose evidence favorable to the accused, no matter how insignificant, unquote. Evidence is only material if, quote, there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different, unquote. The Supreme Court adopted the standard directly from Strickland. And to meet that standard, quote, it is not enough for the defendant to show that the errors had some conceivable effect on the outcome of the proceeding, unquote. But that is all Avery alleged for either Heidel or Romlo, and even that was based on speculation that had no basis in the record. Heidel's affidavit said Ms. Halbach, quote, pulled over to check her calendar, unquote, as she was on the phone with Heidel at 11:35 a.m. on the day of her murder. Nowhere does Heidel say that Halbach was, quote, making notations in her day planner, unquote, as Avery claims. Avery claims that Halbach making notes in her day planner would help tie Hilgas to the murder because a, quote, friend, unquote, said Hilgas had Ms. Halbach's day planner after the murder. But that is also false. The friend said Hilgas, quote, had found a schedule of Halbach's for the week of October 31 to November 6, unquote. Nothing suggests that what Hilgas had was her day planner. Avery further assumes, with no support, that Halbach can't have kept more than one copy of her schedule. Avery then claims that Heidel's affidavit shows that Halbach's day planner was in the RAV4. It doesn't. They have in parentheses, it doesn't. Assumes it must have stayed there until after the murder, and now in parentheses, there are no facts to support this. Assumes that the schedule Hilgas found was the day planner, and then in parentheses, there are no facts to support this either. Leaps to the conclusion that Heidel's affidavit shows that Hilgas retrieved whatever schedule he had from the RAV4, parentheses, again with no factual support, and claims this would have allowed him to meet the Denny third-party suspect test for Hilgas by providing a direct connection to the crime. Apart from relying on too many speculative leaps to count and therefore failing to allege what was needed for a hearing, Avery failed to allege any facts showing that there is a reasonable probability that Heidel's testimony would have led to a different outcome of the trial, even if Avery's many misrepresentations were true. He simply proclaimed it would have done so, which is nothing more than a conclusory allegation. Mere materiality requires more. There was an overwhelming amount of evidence against Avery. No, there wasn't. And he failed to explain why it's reasonably probable that he would have prevailed at trial if Heidel told the jury Halbach said she was, quote, checking her calendar, unquote, during a phone conversation, especially considering that Avery has uniformly failed to suggest how Hilgas or anyone else realistically could have acquired Avery's blood from his sink and then planted it in the RAV4 and failed to provide anything directly connecting anyone else to the crime. Avery's claims about Romlo suffer similar flaws. Avery did not allege anything showing a reasonable probability of a different outcome at trial. Romlo simply said he saw a car on the side of the road that he thought matched, quote, the written description of Ms. Halbach's RAV4, unquote, on a missing person poster at the gas station. So assuming Romlo's contentions are true, just like they assume Bobby's are, Romlo never even knew what Ms. Halbach's car actually looked like because he never saw a picture. There is not a reasonable probability that a jury would have acquitted Avery if counsel produced Romlo just to say he saw a car parked on the road that he thought was similar to a written description of a car he never actually saw. How do you know he never saw it? And Avery has again misunderstood what he had to show. He says only that Romlo's testimony, quote, supports trial defense counsel's theory that the RAV4 was planted, unquote, on Avery's property, and further alleges that Romlo seeing a similar car on a road somehow inexplicably shows that quote, it was possible to access Avery property and plant the vehicle, unquote. I could get on Avery property today. Just saying. Setting aside that Romlo seeing a similar car somewhere fails to establish any fact about the RAV4 being planted or accessibility to the Avery property, let alone a material fact, what Avery alleges, again, amounts to only a conceivable effect on the proceeding at best, and that is insufficient. Once more, and I'm now on page 101 of 130. Once more, Avery has tried to cure the deficiencies in his motions by adding new allegations in his brief. He now attempts to rely on another affidavit from a, quote, Paul Burdick, unquote, that Avery procured, quote, on June 28, 2018, unquote, to corroborate Romlo's tale. Notice how they word that, Romlo's tale. So, really trying to put the words in there to say that this isn't true. Obviously, the court did not have this affidavit when it denied his Brady claim about Romlo in November 2017. Therefore, Avery cannot rely on it to show the circuit court erroneously exercised its discretion in denying Avery's 2007 claim about Romlo. Further, when Avery filed this affidavit in 2018, he buried it in a pile of exhibits with no argument or even any mention of it in the motion then at issue. Avery cannot show that the circuit court improperly denied his October and November 2017 claims based on documents he did not provide the court until 8 months later and then made no argument about, nor can he rely on new arguments in his appellate brief. The circuit court articulated a legally and factually sound rationale for determining that Avery's motion for reconsideration raised only claims and arguments that were procedurally barred, and thus refusing to hold an evidentiary hearing on them. Moreover, the record conclusively demonstrates that Avery's, quote, new evidence, unquote, was only new because he did not exercise due diligence to discover it before filing his motion, that the claims were insufficiently pled and meritless at any rate. Avery has provided nothing to the contrary. Accordingly, this court must affirm this circuit court's discretionary decision to deny Avery's motion for reconsideration without a hearing. 4. The circuit court properly exercised its discretion when it denied, without a hearing, Avery's July 2018 motion regarding Detective Veli's compilation of items copied from the Bobby computer. On July 6, 2018, Avery filed his fifth collateral attack post-conviction motion in the circuit court. This time, he alleged that the state violated Brady by failing to provide him with the CD containing copies of material that Detective Mike Veli located on the Bobby hard drive in 2006. Avery claimed that this CD contained exculpatory material evidence that was, quote, directly relevant to the credibility of Bobby Dassey, unquote, and would have allowed him to raise a third-party perpetrator defense alleging Bobby committed the crime, and therefore the state's failure to disclose it violated his due process right to a fair trial. Yep. The circuit court denied the motion without a hearing, finding that Avery failed to show that any evidence was suppressed by the state because everything on the Veli CD was copied from the forensic copy of the Bobby hard drive that the state turned over to the defense. The circuit court further rejected Avery's claim that the forensic copy of the hard drive was disclosed too late for effective use, noting it was turned over 2 months before trial, along with Special Agent Fassbender's report summarizing what was found. And the footnote says, though this court and Avery referred to Avery's July 2018 and March 2019 motions as, quote, supplemental, unquote, motions, a motion brought after a previous motion has been decided in a successive motion, not a supplement to the already decided motion. Each of Avery's previous motions had been decided when he filed these, so they each were new section blah blah motions. The circuit court did not erroneously exercise its discretion when it denied this motion without a hearing. In Brady, the United States Supreme Court held that, quote, the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution, unquote. The Wisconsin Supreme Court stated the 3 prerequisites a defendant must establish to prevail on a Brady claim. 1. The evidence at issue must be favorable to the accused, either because it is exculpatory or it is impeaching. 2. The evidence must have been suppressed by the state, meaning the defendant must not have had it in time to make effective use of the evidence. And 3. The evidence must be material, meaning that, quote, there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. Avery's Brady claim must fail because he can meet no part of the test. And let me post again. We've been on for an hour now. Here again is what I am reading from, so if you want to read it for yourself. First, as the circuit court correctly observed, the state did not suppress anything. It turned over 2 months prior to trial a complete copy of the Dassey hard drive and Fassbender's report, alerting Avery to what was found on it. Avery does not dispute this. And the Veli CD contained only copies of the pictures and search terms Veli located on the hard drive. Indeed, Avery's own expert, Gary Hunt's affidavit, admits that all, quote, the information contained on the CD is derived from the forensic images contained across the DVDs, unquote. Quote, in my opinion, based upon a reasonable degree of certainty in the field of computer forensic science, the CD contains information and files extracted from the 7 DVDs that, in Detective Veli's opinion, were relevant to the investigation of Ms. Halbach's murder, unquote. And there's no dispute that Avery has always had the DVDs. The state further provided Avery with Fassbender's report disclosing the results of Veli's investigation and informing Avery the state kept Veli's CD. The report stated that on the computer the state located, quote, photographs of both Teresa Halbach and Stephen Avery, unquote, or ... unquote, quote, numerous images of nudity, both male and female, to include pornography, unquote, which, quote, included both heterosexual, homosexual, and bestiality, unquote. Fassbender's report also informed Avery that the hard drive contained, quote, images depicting bondage as well as possible torture and pain, unquote, quote, images depicting potential young females, unquote, quote, images of injuries to humans to include a decapitated head, a badly injured and bloodied body, a bloody head injury, and a mutilated body, unquote. The report further states that, quote, the disc received from Detective Veli, as well as the hard copy pages of instant message conversations, were maintained in Fassbender's possession, unquote. And why is Fassbender keeping anything? The record also shows that the prosecution discussed Veli's investigation with Avery's trial counsel before trial, meaning they were clearly aware of it. The state certainly does not, quote, admit that the CD was suppressed, unquote, from May 10, 2006 until April 17, 2018, as Avery claims. To, quote, disclose, unquote, means, quote, to make known or public, unquote, or, quote, expose to view, unquote, quote. Avery fails to explain how the state, quote, suppressed, unquote, something it told him about, described, discussed, and provided him with all the contents of well before trial. In other words, the definition of, quote, disclosed, unquote. Avery does not point to items of evidence he did not have that were on the Veli CD, but not on the hard drive. He just complains that he could not have, quote, guessed, unquote, what search terms Veli used during his examination. But that is not what is entitled to under Brady. The state must provide the defendant with, and this is emphasized, the evidence. Here, that means the hard drive containing these items, and there is no dispute that the state did that. Brady does not require the state to walk the defense through how to evaluate the evidence, nor to do their trial preparation for them. And that is really all Avery complains he lacked. But it is the material on the hard drive, again, that is the evidence that Avery claims he could have used to impeach or establish Bobby Dassey as a Denny expert. Avery always had that, along with Fassbender's report telling him it was there. The notion that Avery was deprived of the evidence because although he had the evidence itself and had the state's summary of the evidence, he did not have a copy of the state's copy of the evidence is absurd. Avery's argument is akin to saying that if the state made a one-page test sheet with thumbnails of the crime scene photos it found relevant that it kept for itself and provided him with the summary of the relevant photo evidence and full-size copies of all the crime scene photos in a sealed envelope that he did not bother to open, it suppressed the photo evidence because it did not give him the state's test sheet of the thumbnails. That defies common sense. The circuit court properly determined that the state did not suppress any evidence favorable to Avery. Avery makes no real argument that he did not have possession of this evidence, likely because he cannot dispute that he did. Indeed, Avery's own expert, Gary Hunt, attested that he found the very same evidence during his independent examination of the hard drive in 2017, before he even had Veli's CD. Perhaps recognizing that he cannot make a credible claim that the state suppressed evidence that he had in his possession 2 months before trial and that his attorneys discussed with the prosecution, Avery pivots to alleging that though he had the evidence in his possession, he did not have it in time to, quote, effectively identify a motive in its Denny motion filed on January 8, 2007, unquote. and alleges that the state, quote, deliberately misled, unquote, him about the contents of the hard drive. Both contentions are unsupported. The circuit court did not ignore Avery's argument that trial counsel received the hard drive too late to use it. It found that Avery had it months before trial and opted to do nothing with it. That was an accurate assessment of the record. Avery complains that Veli's investigation was completed several months before he received the hard drive, but that is irrelevant. Quote, immediate disclosure is not required under Brady, unquote. Brady does not require that the defendant be provided with the evidence on his own timeline either. It requires, quote, that the prosecution disclose evidence to the defendant in time for its effective use. Avery alleged nothing showing that he did not receive the hard drive in time for its effective use. The state sent Avery the 7 DVDs and Fassbender's report explaining what was found on them on December 14, 2006. That was 7 weeks before trial and nearly 4 weeks before Avery filed his Denny motion. It took Veli only 16 days to perform his examination of the hard drive. Avery provided nothing explaining why 10 days was too short a time to procure a computer expert who then would have had just as much time as the state's expert to examine the hard drive before the motion's deadline, or that Avery even tried to find one. And the motion's date is not set in stone. If Avery needed more time to assess the hard drive in order to effectively develop his Denny motion, he could have and should have asked the court to extend the motion's deadline and possibly adjourn the trial date if necessary. Avery made no showing that he asked for more time to investigate, indicated that he could not access the hard drive, or said anything about trying to investigate the hard drive at any point. Finally, nothing precluded Avery from seeking to amend his motion after it was filed, if he found anything relevant on the hard drive. He did not attempt to do that either. In short, Avery had the hard drive in plenty of time to make effective use of it before trial. He just did not attempt to do so. And contrary to Avery's suggestion, the state did not, quote, deliberately mislead, unquote, anyone about what was on the hard drive. It provided the defense with Fassbender's report revealing all of this information and discussed with Strang that it did not believe the investigation turned up much of evidentiary value. That was an accurate assessment, and Strang agreed. The circuit court did not ignore this argument either. The circuit court explained that Strang's discussions with the state showed that he knew what was found and did not think it was relevant. That the circuit court rejected Avery's arguments does not mean it overlooked them. In short, the state disclosed and provided to Avery both the evidence itself and a summary of what the state found on the hard drive. It further disclosed that it kept a copy of Veli's itemization of these things. It discussed Veli's investigation with Avery's attorneys and whether Veli would be a necessary witness. The bottom line is neither the prosecution nor the defense found the pornography and other computer evidence relevant to their case. I will never understand most of this. That pink fuzzy handcuffs showed that Stephen is a sexually depraved person who would rape, well, only in Brendan's case, would rape this woman that he doesn't know and kill her. But this stuff being on Bobby's computer is of no relevance when Bobby is the last person to see her alive. Moreover, Avery has again failed to establish that the contents of the Veli CD were material. To show that something is material, Avery had to show that there is a reasonable probability that the, and this is emphasized, outcome of the trial would have been different if the defendant had the evidence, which, and now this is in parenthesis, which again Avery had in hand and simply ignored. The evidence from the hard drive would not have altered the outcome of Avery's trial. Avery claims the pornography and violent images in search terms would have impeached Bobby Dassey's credibility. And the footnote says, Avery again falsifies the record. The prosecutor did not say the state found, quote, nothing of evidentiary value, unquote. He said it found, quote, nothing much of evidentiary value, unquote. Schrang said the report showed, quote, nothing of evidentiary value, unquote, on Avery's computer, and that the Dassey computer, quote, the Bobby computer, quote, was not relevant unless Brendan is a witness or his statements are offered, unquote. The fact that someone views violent pornography does not diminish their credibility as a witness, as Avery claims. Though distasteful, it has nothing to do with their truthfulness. Nor would viewing violent pornography refute anything about Bobby's claim that he never saw Ms. Halbach leave the Avery property. Moreover, Avery's claim that this evidence could have impeached Bobby about his timeline of events fails to recognize that this would be cumulative. Bobby's timeline of events was refuted by multiple other witnesses who testified. There is not a reasonable probability that the outcome of the trial would have been different if Avery had used this pornography to impeach Bobby Dassey. Avery's discussion about Bobby's 2017 interview with law enforcement is irrelevant to his claim. Nothing about an interview conducted 10 years later can possibly be relevant to the plausible outcome of Avery's 2007 trial if Avery had Veli CD then. Tracy saying, has there been any good news in this? Let me just comment on that real quick. You don't expect there to be any good news in the state's response. The state is going to continue to lie, cheat, and steal to try and keep these guys in prison. So you expect this to be a hatchet job on Kathleen Zellner's filing. There has been some things in here, and I suppose we could do another video at some point where now we just discuss it and we're not doing just, going through all this legal stuff that those of us who aren't basically a lawyer have a hard time following. Because there are some things in here that I find interesting that, in my opinion, are good for Stephen. But what my opinion is doesn't matter. It's what the law is that matters. And the way our system is set up is that it's going to do everything it can to block anything that would prove Stephen's innocence. Anything they can to stop him from getting back in court, they will do. That's the way it's set up. Once you're locked up, you're going to stay there. Okay. Avery's discussion about Bobby's 2017 interview with law enforcement is irrelevant to his claim. Nothing about an interview conducted 10 years later can possibly be relevant to the plausible outcome of Avery's 2007 trial if Avery had Veli CD then. Avery's materiality argument severely oversells Bobby Dassey's testimony as well. He was far from, quote, the state's primary witness, unquote. As explained above, there was a wealth of forensic evidence pointing directly to Avery, nope, which the state established through 14 expert witnesses, law enforcement officers, and several other citizen witnesses. And the footnote says, further, Avery's claim that Bobby was, quote, searching for key terms relevant to the murder, unquote, and, quote, created folders labeled Teresa Halbach and DNA, unquote, is supported by nothing in that interview, which at any rate is irrelevant to the question at issue here. Again, the issue on appeal is whether whether Avery sufficiently pled his in motions, that's what it says, that constitutional violations happened at his trial in 2007 and on appeal in 2011. This appeal is not about whether Avery can concoct speculative scenarios about events occurring long after Avery's trial and try to prop up whatever latest unsupported theory has occurred to the defense. Avery doesn't explain why Bobby Dassey's testimony saying he did not see Halbach leave the property was the critical evidence tying Avery to the crime, rather than the fact that Avery's blood was found in the victim's hidden car, his DNA was found in multiple places on it, the victim's remains were found in his burn pit, the victim's personal property was found in his burn barrel, and the victim's DNA was on a bullet fired from a gun in his possession. Does say why it was pertinent, or because that's the one of the only things the jury asked to see when they were deliberating. That's why. Nor does he explain how Bobby was, quote, the primary witness, unquote, and not the other members of his family or citizen witnesses who testified, many of whom contradicted Bobby, or the countless law enforcement officers and experts who collected and evaluated the evidence. Even if Bobby said nothing, or if the defense put forth cumulative witnesses to impeach Bobby further, the state still would have made a compelling case that Ms. Halbach never left the property. But if she never left the property, why are her bones? Why was she burned over at the not the quarry, the gravel pit? Where was I? At no point has Avery ever shown that there is a reasonable probability a Denny defense would have succeeded either. Indeed, Avery has again failed to show that he even would have prevailed on a Denny motion had this evidence been included in the motion. Setting aside Strang's and Buting's belated revelations about how crucial this pornography on the computer was, though for some unexplained reason they took no steps to analyze it, despite discussing it with the prosecution and Fassbender's report clearly alerting them it was there, Avery still has not established how the pornography and other violent images would establish a motive to murder Ms. Halbach, nor established anything directly connecting Bobby to the crime. Well, what's Stephen's motive? Why is it that we don't have to have a motive for Stephen, but the defense has to have a motive to point fingers elsewhere? Good point, Pam. It wasn't in Stephen's burn barrel. It was in Barb's. First, Avery cites in apposite law to attempt to establish his proposition that pornography establishes a motive for murder. We have 20 pages left. On which he relies in a non-binding Seventh Circuit federal habeas corpus case that addressed whether introducing at the defendant's murder trial under Wisconsin statute blah blah, the defendant's other acts of owning violent videos violated the First Amendment. Absent from Avery's appellate brief is any discussion of any Wisconsin case actually discussing the Denny standard. Even if Dressler were relevant, Avery still doesn't offer anything showing the pornography consumption would have established a motive in this case. Well, neither does Pink Fuzzy Handcuffs. He says with no support that, quote, an obsession with images depicting sexual violence, unquote, which he never pled any facts showing that anyone had, quote, made it more likely that person would commit a sexual homicide, unquote. But his expert simply states that there is a connection between pornography consumption and violent behavior. That is insufficient to establish a motive for murder. You can bet your ass if they found that stuff on Stephen's computer, they would say that's his motive. Nor did Avery, and they looked for pornography, and all they found was homemade sex tapes he made with his girlfriend. I wonder if Fassbender kept that in his possession too for personal use. Nor did Avery offer anything that would establish a direct connection to the crime. Direct connection requires, quote, evidence that the alleged third-party perpetrator actually committed the crime, unquote. In other words, it has to, quote, firm up the defendant's theory of the crime and take it beyond mere speculation, unquote. And there is literally no evidence connecting Bobby Dassey to this crime. Avery's claims are again nothing but, quote, mere speculation, unquote, unsupported by any facts. Avery has never pointed to anything directly connecting Bobby Dassey to any of the evidence at all, and therefore he's offered nothing showing, quote, a legitimate is emphasized, tendency, unquote, Bobby Dassey committed the crime. Avery has particularly failed to offer anything showing that Bobby Dassey or anyone else somehow had the tools and ability to collect his blood from the sink on which his new defense relies. The fact that Avery has now pointed the finger at 5 different people during these proceedings shows that there is no evidence actually connecting, emphasized, anyone else to the crime, let alone anyone in particular, as is required to raise a Denny defense. Indeed, multiple places elsewhere in his brief, he claims Hilgas, not Bobby Dassey, was the real perpetrator. Right, Lynn? Lynn is saying, no motive is required to convict Stephen. Only should he want to claim Denny suspect, he, as the defense, is required to show motive. Denny motion is messed up. And yeah, right. And they already had in pre-trial saying that he couldn't point fingers anywhere else. And showing that Ryan Hilgas should have been looked at, and here's why. And here's because I can make pieces fit for several different people. For George Zipperer. I see nothing wrong with submitting, here's how these pieces could fit Ryan Hilgas. Here's where these pieces would fit Bobby. It's just showing they never looked at anybody else. They wanted Stephen because of his lawsuit. Okay. Instead, Avery just proclaims that if he established motive for Bobby Dassey, he would prevail on Denny, and assumes that means he would prevail at trial. But Denny is a 3-pronged test and requires a legitimate, okay, I read this already, didn't I? Showing that the third person committed the crime, including showing a direct connection. And Brady requires a showing that there is a reasonable probability that a Denny defense using the computer contents and accusing Bobby Dassey would have succeeded. Avery has not made either showing. Moreover, Avery overlooks the fact that Attorney Buting told the jury that Bobby Dassey could have been the killer during the closing argument. How is he overlooking that? He noted that Bobby stated that they only had 3 burn barrels, but 4 were outside of the house. He pointed out that Bobby, too, had a .22 rifle in his bedroom. He illustrated for the jury that Bobby's timeline did not match up with anyone else's and argued that Bobby couldn't know that Scott Taddock would know precisely when they passed each other on the road unless they concocted a story about it together, and no one going deer hunting would shower beforehand, and that Bobby was home by 5 before deer would be out. He then specifically suggested Bobby was the killer. The jury heard this theory, coupled with a far more believable planting defense than Avery's new one. Now, even if Avery further discredited Bobby or presented Avery's new, quote, the killer planted the blood evidence, unquote, defense, and alleged that Bobby was the killer because he allegedly viewed violent pornography, and there's no probability of a different result at trial. I think that is like the only thing that I differ from Kathleen on, but just because Kathleen has said this doesn't mean that's what she personally thinks. It's, again, you're just trying to show all these could be possible. So I do not think Bobby is the one that got the blood and planted the blood. I think it was law enforcement. I do not think Bobby did that. Okay. But again, it does not matter if the contents of the Veli CD were material because nothing was suppressed. Everything on the CD came from the hard drive, which Avery undeniably had in his possession. Avery also had the state's report showing what the state found on the hard drive. Avery was not entitled to the state's distillation of the evidence. He was entitled to the evidence, which is what he received. Avery had everything on the Veli CD in hand 2 months before trial. Avery's Brady claim simply fails. He establishes no part of the test. Avery's claim that this is somehow newly discovered evidence fails multiple prongs of that test as well. Avery cannot possibly establish that he was not negligent in seeking the evidence when Fassbender's report telling him what Veli found on the hard drive and alerting him that the state kept the CD was in the record both before trial and the whole 12 years that passed since then. Still want to know why Fassbender kept that CD. Did he want to look at that porn? Is that why he kept it? Brett, you said that's true. You wouldn't shower before hunting. Now, I'm not a hunter, but I am told that you would want to get scents off of you. So it's basically just, so he was only in and out of it for like 2 minutes. So it's just like a rinse off, trying to get smells, and you wouldn't use soap and all of that. I don't know if there's anybody on here currently that is a hunter that maybe you can speak on it, because I'm I can't kill anything. So, but that's what I've been told, that it is, because it's something that I thought at once too, going, why would you shower before going and laying in the woods? But no, I'm told you want to get the scents off you because the deer can smell you a mile away. The Veli CD is also cumulative with the hard drive that Avery had in his possession the whole time. Finally, as explained, Avery has not established that there is any probability that the result of his trial would have been different had he presented a porn-based defense that Bobby was the killer and planted the evidence. The CD is not newly discovered evidence. Finally, there is no, quote, cumulative effect of the Brady violations, unquote, because Avery did not establish any Brady violations. As explained previously, Avery failed to allege sufficient facts showing that the zipper CD, Hradant's testimony, the flyover video, Heidel's information, or Romlow's information were suppressed, exculpatory, or material. All the facts he alleged about these things were pure speculation that did not follow from any facts in the record or even from the affidavits he submitted. Accordingly, there cannot be any cumulative effect of these violations because Avery did not establish any violations. Quote, adding them together adds nothing. 0 plus 0 equals 0, unquote. 5. The circuit court properly exercised its discretion in denying Avery's March 2019 motion without a hearing. In his March 2019 motion, Avery sought reversal and a new trial based on an alleged violation of Arizona versus Youngblood. The basis for his claim was that the state effectively destroyed evidence by releasing bone fragments found in a quarry to the Halbach family in 2011, and thus he can no longer seek and possibly obtain post-conviction DNA testing on that evidence. In considering Avery's motion, the circuit court made the following findings of fact. Bone fragments found in the quarry were released to the Halbach family after trial. The bone fragments were previously examined by Dr. Leslie Eisenberg, who had produced reports of her findings. What is on that? Again, if they're not human, why do you give them to the Halbach family 7 years later, after the fact? 2, the FBI confirmed that they couldn't be tested for DNA at that time. That's why all evidence has to remain in evidence, because science is constantly changing. Oh, just shut me off.